Excellencies, ladies and gentlemen, I would like to thank the International Criminal Justice Consortium and the Kingdom of the Netherlands for organizing this important event on the occasion of the Human Rights Day. The ICJC has undertaken notable efforts to pool the expertise and resources of reputable organizations such as the American Bar Association, which is represented here today. Your commitment to the ICC is very much appreciated. The Netherlands has been a strong supporter of the ICC since the very beginning, and it has a special connection with the court as its host state. We likewise have an excellent relationship with our host city, The Hague, which is also known as the legal capital of the world and the international city of peace and justice. I am truly grateful to the Netherlands and the city of The Hague for their partnership and efforts to promote awareness of the ICC's mission. When the United Nations General Assembly adopted the Universal Declaration of Human Rights on the 10th of December 1948, it was the first time that the international community articulated in detail fundamental rights and freedom that belong to all human beings without distinction. 50 years later, the adoption of the Rome Statute of the International Criminal Court in July 1998 represented another groundbreaking development toward a more humane world. In Rome, in the late evening of the 17th of July in 1998, the community came together in the face of moral duty to act collectively in order to protect the most fundamental human values. I do not believe that it would be an exaggeration to compare the spirit of the Rome Conference to the spirit of the Universal Declaration of Human Rights. While the ICC is not a human rights court in the strict sense, it was created to help protect core human rights and values. The crimes under the ICC's jurisdiction, genocide, crimes against humanity, and war crimes inherently involve violations of the right to life and liberty, as well as other violations such as torture and slavery. These crimes also have far broader implications. Large-scale atrocity crimes frequently cause the breakdown of social structures, denying a series of other rights set out in the Universal Declaration, from the freedom of expression to the right to an adequate standard of living and education. In many a time, discrimination based on gender, race, ethnicity, or religion goes hand in hand with international crimes. The unprecedented focus on victims in the Rome Statute provides another important platform for advancing human rights through the ICC. One of the most important foundations of the international criminal justice system, as established by the Rome Statute, is the structural relationship of the ICC and the national jurisdictions. The ICC is a court of last resort, a kind of a stopgap mechanism to prevent impunity. It can investigate and prosecute only when national jurisdictions in question is unwilling or incapable of doing so. Conversely, this means that the ICC is built on the idea that it is primarily the job of states themselves, that is, of their national judicial systems, to investigate and prosecute serious international crimes. Membership in the ICC is therefore an incentive for states to update their criminal laws and to make sure that their police, prosecutorial, and judicial services are able to deal effectively with serious crimes. In this way, the principle of complementarity allows the Rome Statute system to advance the struggle against impunity at two levels simultaneously. One, strengthening the global structures for the protection of fundamental human values, while two, respecting and reaffirming state sovereignty and encouraging the capacity building of national mechanisms to uphold the rule of law. Effective complementarity is the only way to end impunity. No matter how much the ICC does, at the end of the day, it will always be a court of last resort that deals with a limited number of cases. Domestic justice systems should be well equipped to deal with Rome Statute crimes so that they can serve as a strong primary line of defense against impunity. In a national setting, this requires, among other things, that states have an independent judiciary, public support for accountability, a good legal framework, and the necessary skills and resources for proper investigations, prosecutions, trials, witness protections, and so on and so forth. For this reason, it is very important that the capacity building of national jurisdictions is mainstreamed into rule of law and development agendas. In this respect, I appeal to the relevant agencies of the United Nations and to all other actors in rule of law and development to pay due attention to Rome Statute-related issues. Excellencies, ladies and gentlemen, in my opinion, deterrence is the overriding ultimate goal of the entire international criminal justice system that we are building with the ICC at its apex. In certain situations where the lives and security of entire communities are threatened by mass violence, the risk of prosecution before the ICC may be the crucial and unique deterrent that will stop leaders from abusing their position to the peril of innocent civilians. history has showed that in the face of the worst atrocities, national systems are sometimes either unwilling or unable to act. For instance, due to the partial or complete breakdown of their domestic judicial infrastructure, or because of political reasons, in particular if the suspected perpetrators are high-ranking persons close to the country's leadership. This is why we need an effective and independent permanent international criminal court to provide a strong deterrent effect. The ICC system aids prevention also by other means. As more and more states harmonize their national laws with the Rome Statute, and as we spread global awareness about the need for accountability, we can see progressive entrenchment of both legal and social norms prohibiting mass violence. Excellencies, ladies and gentlemen, it is remarkable how far we have come with the ICC, but at the same time, countless challenges remain ahead of us, and a tremendous amount of work remain to be done. Some of the key challenges concern the effectiveness and efficiency of the ICC. For effectiveness, the cooperation of states is absolutely crucial. By joining the Rome Statute, states accept the responsibility to cooperate fully with the investigation and prosecution of cases at the ICC. The various forms of cooperation range from the production of the evidence and facilitating access to witnesses, to arrest, freezing and seizing of assets, and the enforcement of sentences. It is vital that states provide timely and comprehensive cooperation to the ICC. Otherwise, we cannot fulfill our mandate effectively. In this respect, one of our frustrations has to do with the fact that when the UN Security Council referred the Darfur and Libya situations to the ICC, it did not impose an obligation on all UN member states to cooperate fully with the ICC on these investigations. Furthermore, the Security Council has not done much to help us overcome serious cooperation problems with Sudan and other countries. Much like states have the obligation to respect, protect, and fulfill the effective enjoyment of human rights, governments can play a key role in raising awareness about the international criminal justice and inducing a public atmosphere supportive of accountability. The ICC also has to do its own homework. We all know that international trials are, by their very nature, complex and lengthy. But that is no reason not to make every effort to speed them up. And indeed, the ICC is working very hard on improving its efficiency and expeditiousness of proceedings, while fully respecting the procedural and human rights of procedural fairness and human right of suspects and the accused. For this purpose, we have developed a lessons learned exercise to streamline the judicial process, and we continue making steady progress. Excellencies, ladies and gentlemen, I am positive that the promotion of the ICC means promotion of human rights, and advancement of international criminal justice means advancement of human rights. At the time when the international community is grappling with reports of terrible atrocities in various parts of the globe, it is more important than ever to promote the universality of the Rome Statute. It has been a monumental decade for international criminal justice, but the fact is that large parts of the world population fall outside the legal protection provided by the Rome Statute system. That includes citizens of the United States. Let me recall that the US played an important role in the birth process of the Universal Declaration of Human Rights. And this country is no stranger in international justice. From Nuremberg and Tokyo to the establishment of the ad hoc and hybrid tribunals in the last 2 decades, the United States has usually pushed hard for international justice. And in the last years, it's been willing to show a stronger commitment to positive engagement with the International Criminal Court. Ratification of the Rome Statute by the United States would no doubt encourage countless other countries to join the ICC as well. This would be an enormous boost to international efforts to protect the vulnerable from the most brutal acts of violence. There is no doubt that the United States is one of the world leaders in areas ranging from science and popular culture to industry and trade. I call upon the United States to exercise its leadership and influence in international criminal justice as well, by ratifying the Rome Statute as soon as possible. Let us remember that today's world is strongly interconnected. No country can prosper in isolation. If we want to ensure a safe, peaceful, and harmonious life for our children and grandchildren, as well as people everywhere on the planet, we have to take joint action to enhance the protection of all individuals. As president of the ICC, I have invested a lot of efforts into encouraging more states to join the Rome Statute system. Time and again, I have engaged in lengthy discussions with government leaders, policymakers, parliamentarians, and civil society. I have clarified misperceptions, explaining that ICC is not a replacement of national courts, and that ratification will not give the ICC any power to dig up things of the past. Joining the ICC is not a method for settling old scores. It is an insurance policy for the better future, both for the states that joins entering the protective shields of the Rome Statute system, as well as for the rest of the world. States should not only ask, what will it give us? They should also ask, what will it give to humankind? I want us to build a world where borders will not be an excuse for impunity, and where everyone knows that accountability for international crimes is inevitable. It is only with concrete actions, both at the local and the international level, supporting the ICC's mission, that can we get closer to ending impunity for atrocious crimes that cause untold suffering to our fellow citizens of the world. Thank you very much.